Chris is someone who needs very little introduction. He's a very famous barrister, professor, accredited mediator, chartered arbitrator, also a chartered engineer, and also chartered information technology professional. And he worked in many cases, commission on inquiries, and of course litigations as well. Please put your hand together again. And welcome all of you for coming to our the third Fireside Chat, which we hope to do once a month count. But without further ado, let's go back to our discussion today. There's no one better I can think of than our Professor Joseph to plan us. You asked me to call Chris and make it casual. As a commercial lawyer, often we see the front end of it. We draft the contracts. Hopefully nothing goes wrong. Usually nothing goes wrong. It never goes wrong. But one of the things we do, of course, is we know, apart from putting litigation clause, we will put a dispute resolution clause that we already know mediate first and arbitration. But there is something called an escalation clause where you would say, do this first, let the boss talk first. If it doesn't work out, then go to mediation. Oh, you've got a mediation, you must start to know about this International Center for Mediation. As you go to mediation arbitration, there is something called escalation clause. Well, let's learn from Professor Chris what are the latest developments about an escalation clause. I heard there are many cases, but there's a particular case that's going to court of final appeal where a party is saying, the court have no jurisdiction to suggest that whether a party have met the preconditions set up in the escalation. Chris, could you guide us?
Nick, thank you very much. And thank you everyone for inviting me. And Nick is very kind. I think my aspiration, I think some of you will know, I have a very passion for teaching. The reason why I want to teach is simply because I've reached a certain age in my life. By the day, you need to have succession planning. I was telling you. And if we want to continue to Hong Kong to show the world that we do have the expertise, we haven't lost it. It turns out you need to go to the next generation. That's the key. And today, most of the stuff that's prepared, it's not by me, it's by my pupil. Who's this? Trying to fall for now. You prepare all the things, and I'm just telling you what she said. But the key thing is today one of my colleagues in my chamber said to me, I must learn about arbitration. So I asked her why. If I don't, I won't have any work in litigation. Because all the cases are going to arbitration. Every single barrister is learning about arbitration. So whether it's true or not, I don't know. Maybe David can enlighten me on that. But more people are learning arbitration than 20 years ago. When I started doing this, 20, 30 years ago, everyone says, you're nuts. Why are you doing arbitration? No business. But now you can see more cases. Now, going back to this escalation clause, I think it's very important. It started in UK. People talk about when you draft a dispute resolution clause, it has to be clear, precise, what the party's intentions were. And the judge in this case, called C&D case, the Court of Final Appeal, said very clearly, for example, that is relating to admissibility. It's not relating to jurisdiction, so the matter has to go to the arbitrator for him or her to decide whether, for example, you've actually complied with the escalation. Now, I think escalation clauses, or sometimes in construction we call tiered dispute resolution clauses, I think are very effective. Why? Not all disputes need to go to arbitration. Some disputes, if the bosses, as you mentioned, sit down over young child can agree on it, perfect. Okay, end of the day, certain disputes are suitable to go up, but not all disputes. Okay, at the end of the day, if you ask a client to push everything towards arbitration litigation, eventually they're going to look at the dollar side, and they're not going to be trusting the legal system anymore because it's costing them too much. So I think you as an advocate or as a solicitor have to advise your client appropriately which avenue would be the best from their point of view. And I always believe this scenario is, I always go to the same doctor all the time, medical doctor. Why? I don't have to go and explain to this doctor all the time my symptoms. He knows when do I need to do this, when do I need to do that. And the way it's saving me time, saving me cost. So if clients, rather than go around and shop around for lawyers, you should actually stick with one lawyer. If that lawyer knows your business well, it turns out you can save costs going forward. So that's why I believe that whenever you're drafting dispute resolution clauses, sometimes it's better for you to actually not just focus on your way of doing it, also talk to someone else. Maybe the transactional lawyers can speak to the dispute resolution lawyers and tell them what's happening and see whether they can come up with a appropriate clause to put into the dispute resolve the contract.
20 years ago, I first met Chris, and he was then the Solicitor General or the Secretary General of HKRAC. And he gave me, a young lawyer, a chance to write the domain name dispute resolution rules, which because I'm background, but I knew little about what in. As for, of course, why is he asking a young kid to do it? He must know this better. But anyway, I really learned a lot from it, give me a chance to learn this new area, and for that I thank you. One of the things I learned was, after certain ages, how to write a good judgment or write a good award. What is a good award, in your opinion? Is it an award that avoid being challenged in court or by colleagues or by peers? What makes a good award?
I think when I was learning first at City University of Hong Kong about the gentleman called Stephen Ho. Stephen Ho is now with Chinese University. He said to me, whenever you're drafting a contract, it should be clear, simple, and easy to understand. I agree, totally agree. But when it comes to an award, if you draft something that's clear, simple, easy to understand, the client's not happy. Because why? Because Labour actually spent a lot of time addressing you on different issues. In your award, when you draft it, you have to address every single issue. Why? Because you have to satisfy their needs. Now, if you don't address it, they're going to say you've not covered it. Even at the very end, we said, I've read everything. Even though if I've cited an award, I've read it, I understand it. They're not happy with that. They still want you to address it somehow in the award, sort of, for example, at least from accountability point of view, going up, they'll say, at least everything has been addressed. Whether they like it or not, it's covered. But if you don't cover it, you feel that you haven't done your job. You missed it somehow, and you haven't addressed it. If you don't address it, they feel uncomfortable. For example, when people talk about challenging awards, it's very difficult to challenge whether your award is sufficiently long enough to address the issue. There's no such thing. How long is a piece of string? I think there's a case for example, in UK, and also a case in what they call the Cayman Islands. They talk about, for example, how long is a piece of string? How much do you need to write? Okay, as long as it dispenses with the issues at hand. So I think, given that arbitration is a service industry, given that parties are paying you as an arbitrator to do the work, at least from my point of view, whether it's a moot point or not, I still have to address it within the award to satisfy their needs. And recently, I think my Jennifer raised a question or raised a case whereby the COG case and said like this, that Mimi Chan said very clearly that the reasons for the award do not necessarily need to be elaborate or lengthy, provided they could be understood in its proper context, particularly in private consensual processes such as arbitration. So what she's saying is, as long as it's understandable, the client understands it, that you've addressed it to the extent you believe it's not right, and they're happy with it, at least you've done your job.
How is that comment from Mimi overlap or not, or is consistent with Article 34 of the model law?
Now, Article 34 says you challenge it in terms of, for example, certain procedures, like, for example, whether notice was given, whether the parties had the ability to present or to be heard. None of it says about the award. Okay? But people, as you know, if they're not happy with something, they want to challenge anyway. So the chances are, at least when the judge reads the decision and says that, oh, your decision is very clear, so the ground to challenge won't be there, even though I call this Article 4 is not covered.
So a lack of reason, is it a valid reason to challenge an award?
It's going to be very difficult. But of course, clients are not happy. They're going to actually ask more senior counsels, more counsels from UK, and also senior counsels from Hong Kong to say, can you find any loopholes there that we can challenge it?
And so although Article 34 does expressly say that the reason is the reason, a reason, challenge, but in practice, it's something we should deal with. Do you call arbitrators who made up their mind, wrote the award before they walk into a room to conduct an arbitration?
Yes, I sat with some arbitrators, I won't mention their names. They've already, before we even have the hearing, they've already read everything. And they said, this is my point of view. And that's hard. that says you shouldn't do that. You should actually listen, because at the end of the day, you need to listen to the evidence. What's written down might be slightly different from how they project it. So the chances are you need to listen to the evidence and make up your mind whether this witness is really telling the truth or whether this witness is basically making things up. So you really need to hear the evidence, because if you don't do that and you make up your mind before you go to the hearing, you haven't done justice to the parts. So you really have to give them an opportunity to present and be heard.
I had a teacher when I was doing my fellowship for arbitration. I was taught one way to write, what approach to write, and what you tell me one thing of this is to, after you've read everything, heard everything, you make a decision which side succeed. And then you start off writing about the strongest points of the losing side, and you write the first few strongest points, and every point that they think is strong, yeah, I heard you, I wrote it down, this is what I think about it. You set a good approach.
It really depends how I do it, because I think most people are thinking given Dennis Stowes. I usually get both parties to actually come up with a list of issues they have to resolve, and it's often in a fashion they feel comfortable with. And on top of that, I'll also ask them to list out issues they don't have an issue with. So basically what happens is I tend to address the issues they don't have an issue with in the award first. Right. And then after, then I go through categorically one by one, what is listed accordingly, one issue at a time. So the way I'm not really cherry picking certain issues and reading them first. Yeah. I'm actually saying, okay, I'm following what you have said to me, and I'm following accordingly. And in the very end, then I'll summarize, for example, my B points based on all of those issues you raised.
That's when we have found people like Joyce, who was a successful in-house lawyer in a financial institution, and many companies, law firms as well, I'm sure, are looking into ESG, how we can contribute more. But is there more ESG issues? Are there ESG-specific issues relevant in the arbitration context that we should become more aware of?
I think one of the ones that I would such that identify is when you talk about ESG, environmental sustainability and governance, I think most of the time it tends to talk about governance when you talk about legal issues, whether a certain director has complied with the contract and so forth. We talk about the governance. We have a lot of those issues. In terms of environmental issues, it's coming up. It's more focused on the public policy point of view. So people are looking at that environmental issues, like if you look at, for example, Glasgow recently had, for example, one of the issues talking about global climate and all that stuff. And I think it hasn't really boiled down to the private sector per se. Sustainability, likewise, okay? It basically ties focusedly most on those two issues. But at many organizations, including the PCA, the Hague Convention, sort of the Hague rules, they also mention that you should follow certain rules in terms of arbitration, and if recommended, the unseated arbitration rules. And if you look at the unseated arbitration rules, they don't specifically address ESG methods. Okay, so that is something, for example, that we need to develop further in terms of how we address ES at least. Governance, I'm okay with that because you can address that in terms of the contractual agreements and so forth. But in terms of ES, how do you address, for example, public issues with private issues together within that context? That's something that basic, because some people will argue this is outside the scope of our agreement. It's a more public issue.
So, but there are people in the ESG space who sort of double count their carbon credits. There are people who promise to sell people carbon credits by reducing their own emission, but they fail to deliver. Then there's reinsurance and carbon credit trading. Now, are you saying they is now starting to be developed to have an industry view about let's put in arbitration, and that's in particular clause for arbitration?
I don't think there's a particular view towards moving towards arbitration. But I think that it boils down to contract. For example, if I agree to do carbon trading with you and certain amount, so it's like an agreement. But I think the terminology has to be clear. And for example, whether people want to go into the space of arbitration or litigation. And if it's, why do people want to focus on arbitration? Because I think it boils down to one aspect, a New York Convention on the reciprocal enforcement of arbitral awards. Because people believe it's a contract. If I have to enforce it, I need a convention to enforce it. Whereas for Hague Convention, not many countries have signed it. So even though, for example, you have the court litigation and all, it might be difficult for you to enforce that in a different jurisdiction.
But just like some lawyers or decision makers in disputes, they would say, IP ownership, I won't go to arbitration. I want to go in corporate. But ESG also is not just affecting private interest, but also corporate interest. Is there a drive towards keeping it in litigation?
Now, if I was a company, give you an example, and if I basically have to go to court, and the court basically lists out all the issues that I haven't complied with certain requirements of ESG and so forth, that could be embarrassing. I think it could be embarrassing in the sense that it goes to the exchange, and they'll find out, you told us, for example, you've complied with all this, but this document says you haven't. So then you have to go back and explain things, and that could be a nightmare. So that's why people are moving towards arbitration, I think, basically because they want to keep things private, not because they got anything serious that they want not disclosed, simply because they don't want any more trouble. Because basically, when people read stuff, they realize you haven't basically complied. Yeah, and it could be a letter from the exchange saying, wow, you haven't complied, so you have to explain. So you have to go through the motions of explaining your stance. So I think that's what they're trying to do. Not because arbitration is more favorable than court litigation, it's just because people just want less hassle.
Can you tell us a bit about this and how we're doing compared to our friend in Singapore?
I think compared to Singapore, we do much better because in a way, we define it. Basically, it relates to outcome-related fee structures for arbitration. But I think we're doing much better because in Hong Kong, we do have 3 heads. The first head relates to a conditional fee arrangement, and the second one relates to damages-based agreements and a hybrid base. And I think if you look at Singapore, they don't really have this hybrid base. Like in Hong Kong, we do have the hybrid base. So chances are, I think we are much more advanced in terms of innovative ideas. So I take my head off the Law Reform Commission in actually coming out with this hybrid process. I think that will help Hong Kong in terms of actually giving more sort of impetus for people to come here. Now, I'm pretty involved with one of the funders, and I was telling one of your colleagues here that basically they're coming out to do a presentation. And I think one of the issues that they always focus on is they always engage external counsel or external solicitors to actually assess whether this case is suitable for funding. And they do have a template that actually we have to tick the boxes to see, for example, whether this is suitable and so forth. And after that, then we have to give our opinion at the very end whether this case is suitable to get funded. Now, many funders are very conservative. Okay? Even though we give our opinion, it's possible to do so. They always come back with more questions asking, have you looked at this? Have you looked at that? Have you addressed this? Have you addressed that? So you can see that funding is possible, but the hurdle to get our funding is very high. Not easy.
In terms of the percentage of share that a law firm can have, or the funders can have, now how does it compare to other jurisdictions? Do you think it's fair?
I think it's comparable. It really depends on, sometimes it depends on each case. So for example, if you've got a strong case of loss, for example, you'd have more shared. But if you've got a weak case, and what will happen is the funders not willing to give you so much.
I mean, with all this flexibility, to allow the customer, the client, the business community to decide what's best for them, I think it's a big thing.
I think one of the good things about it is because if someone owes you money, you don't have the money to pursue the case, then you've lost. But with this, at least, for example, if someone's willing to fund you, at least you stand a chance of getting what we want, and also justice is seen to be done. But I think that is a very good point. But when this started off with, people thought that, this is going to benefit the lawyers are going to benefit out of this. But I'm seeing more, actually, clients benefiting. At the end of the day, some cases they'll say, I don't have a chance because I don't have the money to do it. But if they have funding to do it, the thing turns around.
Cryptocurrency trading. Does anyone have a crypto wallet here? They can open and share. But cryptocurrency, big space, JPEGs. So, with those sort of cases, smart contracts and so on, and often we don't know who's a big whale, who controls most of the currency in that platform. Is there a way to solve these disputes with arbitration?
First of all, I think people are very imaginative, innovative in terms of ideas. And I always come down to the basics. Whether it's cryptocurrency, whether you're dealing with ESG, it all boils down to your contract. Okay, you have to go back to basic principles. And for a contract, you have to have meeting of minds. When you're dealing with cryptocurrency, you don't know who the other person is. So even if you go into the contract with them, the chances are if there's anything that goes wrong, there's a loss on your point, we really assume it. You try to sort of take action based on the contract, but you look at it, realize, for example, it's going to be very difficult for you to pursue that. So you need to know the entity you're going into business with, and so that you can actually pursue that. And sometimes cryptocurrency, there's lots of uncertainties to have.
And are there ways to resolve disputes where you don't actually know the counterparty, the real identity? Someone will show you cryptocurrency by marketing to your metaverse. And
I think that's why the SFC recently, I'm sure in different cases, are trying to protect sort of small investors' interests. Meaning, at the end of the day, sometimes you don't know whether behind the scenes they're legitimate. So I think that's why you have these regulators around the world who actually go in and try to actually tell us whether this is a legitimate business. If it's a legitimate business, and clearly if there's action to who do we actually sue or take our case to. So I think you need to actually be guided by these regulators to actually pursue, if you want to go into cryptocurrencies, whether those currencies are bothered about.
The economies around the world are seeking to go for a good, quick economic recovery are looking to Web3. Now, one of the things they do is looking at DeFi, decentralized finance, where the ability is not meant to be, under the model, not meant to be an issuing bank, for example. Or issuing the crypto. So people in that community, in some ways, would have to sort of look out for each other. Otherwise, the whole platform would go bust. The reputation tank. So, do you think it's a possibility that we could have crypto wallets as a unit, so that we could resolve the dispute and people stake money in making a decision?
I think this is not just a Hong Kong issue, this is one international issue. And I think we need to have some compliance overviews. And I think Joyce, working for the bank, I'm sure when she lends money to someone, if someone's on a screen, you can't see their face, will you borrow money to them? The answer is no. So chances are you need to know the person. You need to know behind the screen who that person is. And so chances are, I think if we have all these checks and balances where the regulators have all these things in place, I think it will be a more safe environment to do so. If not, if we don't have that, the chances are it's free for all. And what happens if you lose money, you blame the government. Why did the government regulate? Why didn't the government do this? Why did the banks look into this? So chances are you can't blame. So I think the strong check has to be in place.
Some people still do, right?
They always blame somebody else. There's nothing at all. But at the end of the day, I think you have to be aware, including these WhatsApp messages and read that sometimes these are false. So sometimes you pick them up and you say, okay, this is a valid one. It could be false. Before you actually commit, you have to say, okay, Nick, he sent me WhatsApp and he wants to borrow $1 million. And I said, the first thing I'm going to do is I'm going to call Nick and say, Nick, did you send me a WhatsApp asking for $1 million? And you're not going to send the money over to Nick straight away. The chances are these are the checks and balances that consumers need to do before they even engage into business. Like in banks, remember we talked about Lehman Brothers. People say, oh, the banks lost a lot of money. Now the banks have to go through a process. When you go and ask them to do anything, they say, okay, let's sit down and record what we said on the telephone. Why? Because they don't want to have any discrepancies, any misunderstanding. So you committed to this, you agree to this, it turns out then we pursue it.
Fred, in this one, did you get involved in issuing legal opinions about white papers for cryptocurrencies? It'd be interesting to hear, where do you take on those cases, especially aftermath of JPEGs? If you would want to give a legal opinion that this is good, but of course you might not have heard the full picture when you ask to give a legal opinion. Let's ask the Vice President of the Law Society. Well, they will say very false.
Because the legal proceedings are...
not specific to that issue, not specific that client, but generally, maybe are there ways lawyers should be careful of when taking on these kind of cases in terms of issuing opinion about white papers of different crypto?
But I think this is based, the economic advice that is based on a knowledge that I had. And today we had knowledge of all the basis on which it was based to write the white paper there is. And there's a risk, right, if you're going to do that. You're going to express opinion on something that's not yet formalized. And so you're going to have to say
Reputational risk.
it's a risk that we have to take on primarily in these things. I think it really depends on how much information we have. We have a lot of click-through contracts, so they have arbitration mediation process as well. And this is but then without thinking about what a tree arbitration or a mediation process. Do you have any views of click-through contracts?
Yeah, recently there was a case, I think that people know that, for example, someone sent a notice with the wrong email address and it went to court, and the court did not enforce our law because the notice wasn't valid, simply because the email address was wrong. So I think, yes, you've committed to it. At the end of the day, most people say that you've read it because you've clicked it. Because if you don't click it, you can't move on to the next slide. But to be fair, okay, you have to look at each case on its own. If a gentleman or a lady who is 70 or 80 years old, they don't know how to do it, but they just realize that if you just press this button, it goes on to the next page. And basically, you have to look at all the facts, the evidence surrounding the whole thing before you can come to a conclusion. You can't just base on, I clicked it, I moved on, so you're committed to it. I think that's what we talked about in most cases related to the factual matrix. You look at the factual matrix of each case, because each case might be similar, but each case might be different in a certain aspect. So I think you have to look at the facts. Well, so that's why nowadays quite a lot of people are now going to links, especially banks, which I think they're doing very well in terms of actually explaining to the client and say, okay, now I've explained it. Do you understand it? Which part you don't understand? Now, once you've explained it, the banker will say, now, before we proceed, I would like to record what we've agreed on so everyone's all clear. So there's no misunderstanding. So I think what they're doing is they do the 3-step process. They're not just previously just telling you, please sign here, okay? Which previously we all know. And banks basically filled in all the forms for us and told us to sign. And now they're actually gone to lots of links where I've actually explained the document to you. And I think that is helpful for the consumer, at least.
Can I ask you about in the world we're in, the economies in the world isn't great, and a lot more insolvencies. Have you been in cases, or have you heard of, you're not supposed to talk about your own case, have you heard about cases where one or the parties are in insolvency? Should there be a state of proceedings, or do you just follow the arbitration course and get on with it?
Now, I think most people have an argument. Why? Because they don't believe they're insolvent, and they have a lot of issues. And I think if you've drafted a contract and said that you're exclusively going to arbitration, then you should respect the party's wishes, because it's consensual. And I think in Hong Kong, many courts, I think the Court of Final Appeal in the case, they say, for example, that we'll stay the proceedings, you go to arbitration in the jurisdiction, you come back, and basically whatever decision you have, then we do look at it and we'll decide. I think that's the right way to do it, because end of the day, you do not know what the company's strategy is, because people are trying to insolvent the company or bankrupt a person because they might want those assets. They might want to do things behind the scenes we don't know. Okay, so chances are, if there's an exclusive jurisdiction clause that calls for arbitration, they've agreed to this, it's consensual. Okay, they've agreed to it. Chances are you should allow them to pursue it first, add their grievances. If it's the arbitrator has decided, okay, you're definitely insolvent or you're definitely a bankrupt, then the courts will take action accordingly. I think that's the best way to do it. If you haven't agreed to that, of course, then you go to court litigation. Then basically, then you have to be at that accountability, and then you have to defend your case in court.
I haven't read the case in full, but I thought that was an interesting case. Sisterma, I think the decision was rendered June 2023. It's between the same parties, but then perhaps unknowingly they signed contracts in China and then in Hong Kong, and then those contracts provided different dispute resolution methods. Right. But then I'm not sure whether they were, properly represented. Perhaps they weren't. So there were inconsistency as to how they will resolve those disputes, whether it's by court. I think one of them said, they were submitted to the non-exclusive jurisdiction of Hong Kong law, blah, blah, blah. And then the other one, it's by arbitration. And then in the end, they went to court just to sort of determine how best they should resolve things. I haven't read it in detail because I'm about to go to a conference, and then I'm supposed to sort of update, because every country, that conference, it's amongst IP practitioners from different countries. So every representative from each country, they will do something about, updating, what's the latest thing. So I was taking out, the recent cases.
Yeah.
I'm not sure whether sort of anyone here is familiar with that case, but I thought that's a sort of pretty good reminder, because commercial transactions nowadays, it's not just one jurisdiction.
Yes.
And it's something that we really have to be very careful with.
Yes.
And then very often with business transactions, sometimes, they always do things in a hurry, and they may not consult
That's right.
their legal advisors, and they would just kind of sign, thinking that, they're all insane. Yeah, I have a name here, and it's Sisterma against CT International Limited.
No. I think it's a bit odd. But I think it boils down to interpretation. And I think the case that we're all familiar in the PCLL, most students will know, is the Jumbo King case. The Jumbo King case about, for example, illegal structures, about interpretation of the contract and so forth. I think that if you look at the contract, I think most people, there tends to be inconsistencies. People are rushing, as you said. So I think what you have to do is the judge is not going to reinvent the provisions for you, but the judge is going to understand what were the intentions behind your drafting, and also to look at the surrounding circumstances, as well as look at from an objective test and see which one is more relevant to the case at hand. And I think that's what they're doing. I think there are many cases, and I think the Jumbo case, and recently there was, a few years back, there was a case, I can't remember, the DIO case. I went to the Court of Appeal as well, also talked about interpretation. And that was Justice Ribeiro gave the leading judge in that case. And I think in UK, I think the case is very, very familiar with all bankers, investors' compensation scheme.
If you look at that case, that started off in terms of interpretation as well. Inconsistency of provisions relating to different contracts, which one will prevail. So I think that all boils down to the same thing. So I think my feeling is, going forward, will those cases drop? The answer is no, because as you said, people rush to draft contracts. So interpretations will still be the flavor of the month in courts.
But it's
People could support it's the same, but it's just that for business, they just have to be more aware. They say not sort of rushing to case, and it is just to make sense, right?
I suspect that there are a couple of other cases. Sometimes I venture to guess, I'm sure that's not the case in most cases, but some jurisdictions have VAT, some jurisdictions do not. For tax reasons, stamp duty reasons, sometimes you break it up in different contracts. Sometimes we don't want a certain kind of people to look at the overall structure and business arrangement for various reasons, and then they put in different clauses because so-called standard form. But maybe I invite Chris to talk about consolidation of different cases, even where the original contract did not talk about the possibility of that, and they actually use sending the case to different arbitration commission.
Yeah, I think maybe going slightly before I address that, maybe going back slightly. I think talking about clients have to be aware. Now, clients are always looking at the bottom line, the dollar sign. If they can save money, they can save money. Usually what they do is basically they go to the website and look at AALCO's website. Well, very good clause. So I cut and paste and put this in. And then they're looking at another organization. Oh, AALCO doesn't have this provision, so we add it in. So there's inconsistency in drafting. And I think clients don't realize that if you prepare at the very beginning, we can save a lot of money at the end. Because at the end of the day, the three issues that people will challenge in arbitration is first is, there was no intention for us to go to arbitration. Okay. Secondly is the contract drafting provision is not clear. It's void from the very start, so they'll argue the second point. The third point is they'll try to argue the arbitrator was biased. He never disclosed certain information. So before you even get to the statement of claim, You already spent a whole year trying to argue all these points. So at the end of the day, it's very important that you engage the right lawyer at the very start to help you do the drafting. If you do that, the chances are you save money in the back end. If you don't do that, that could be a problem. Now, going back to the consolidation issue, under the law, in arbitration, we don't really have consolidation per se, except for under Schedule 2 of the arbitration ordinance, whereby you can consolidate. That tends to be more domestic related cases. But in saying that, you can't automatically say Schedule 2 applies. You have to expressly agree in your contract to include Schedule 2. If you have it, the chances are you can't force someone to consolidate. Now, in other jurisdictions, they do have provisions for consolidations. Now, in Hong Kong, the most famous relating to consolidations is in construction. The employer used to be a developer, hires a main contractor, and the main contractor subcontracts the work to the subcontractor, and you have two contracts. And the issues touch on the same matter. So you try to consolidate them, but usually one party will say no. So it's going to be very difficult. So that's why drafting what we call multi-tier, multi-party provisions are very important. And this is whereby a skills of a lawyer comes in and will say, okay, if there are so many parties involved, how would I draft a contract so that if I have a dispute, it might touch on, say, another party, how can I bring them into equation? In courts, we have that. Joinders, we have all that. Okay, but in arbitration, we remember it's consensual. We can't force someone to do arbitration. So we can't point a gun to their head and say, please consolidate, because at the end of the day, they haven't agreed to this. So I think we need to be more smarter in drafting multi-party provisions within the arbitration clause. And I think that will help.
Can I switch gear to ask, in this new normal, often the countries who implement unilateral sanctions against international law, but they do it anyway. How does that impact on our practice as arbitrators?
Yeah, my personal view, I think that if we have internationally, if we adopt a rules-based way of actually operating, we should stick by it. We can't unilaterally suddenly say, okay, if this is not favorable to me, I'm going to change it. I'm going to do certain things. Because if you do that, then people will say, it's so easy because you've got stronger power, you can change things. I think we have to be seen in the eyes of the community that we are fair to everyone, not just ourselves. Because at the end of the day, if you just look after your own interest, the chances are people feel that it's not fair. The system is not fair. Then why should we actually be bound by those rules if everything's not fair? So I think my take on this is if you develop some rules going forward, it should be fair towards everyone, not just a single group or how should I say, a small group of individuals. I think it has to be fair to everyone so that people can see that the rules, the law are fair, not just for the people who are wealthy, but also the people who are poor as well. I think that's my take on this. And I think going forward, I think certain jurisdictions might adopt certain rules to restrict certain things, okay? But at the end of the day, if the parties have agreed to arbitration, it's consensual. If you suddenly impose something onto them, you're actually imposing something that they didn't really want in the first place. So the chances are that is something that I don't think is right, from my point of view.
I did recently the UK has passed some law decision impacting on UK passport holders, including BNO holders, not being able to provide services to sanctioned partners. How does it impact on your real practice? Should you withdraw from the case as a neutral? You're often the neutral, the middle person, to up to the decide on the third one. You being the neutral third one, presiding one. Does it affect you? I mean, anyone in the position, or specifically you?
I think you have to look at it from a more pragmatic point of view. Before someone is proven to be guilty, you need to give them a fair trial. And you're saying to that, because, okay, you can't provide services for this person. So then he is not being represented. He is basically under a situation whereby he can't defend himself. And suddenly he's guilty, he has to go to jail. Do you think that's fair? So the chances are, I think when we're providing services, at the end of the day, we should, I think government shouldn't impose restrictions on people representing parties if they have engaged you, simply because they have a right to do so.
Yes.
So I think that is the fundamental right we talk about, that people have a right to choose. And if you suddenly put a sanction on someone and they can't represent you, do you think that's fair? I think if you look at it from that point of view. So I know I might be in a minority in terms of this, but I still believe that everyone else should have a fair trial, and you have a right to choose who to represent you. And if you basically chose that person and you still went to jail, at least you have the right to choose. Okay, but if you don't even have that right, the fundamental right, so where's justice? How are we going to move things forward to tell people that we have a fair and sort of a justice society? So I think that's very fundamental.
Well, questions, comments?
What do now? Some people may disagree. Some people might say that governments have a right to do this, but I feel that everyone has a fundamental right to be represented by people they can trust.
Put the addition is on.
Yeah.
That's it. All right. Thank you. I want to talk about both the online dispute resolution. You said the next big thing is already a big thing. Where do you see it go?
And when Dennis is over there, Dennis is with AALCO as well. I was pushing for domain names at the very start because at the time, because my first degree is electronics. So at the time, I believed that we should be doing things more electronic. That was about 20, 30 years ago when we first met. There's domain names. And at the time, I said, okay, we have a domain name dispute. It involves I think it was a school. And we had to go to WIPO. And I said to myself, wow, WIPO in Europe. I says, why can't we resolve it in Hong Kong? Then I looked and found out, no, there was only organizations, WIPO, Canada, or America. And I says, what about Asia? We didn't have anyone from Asia or even Africa and so forth. Then I said, maybe we should explore this. Then I went onto the web page and I saw the organization involved was ICANN, the Internet Corporation for Sign Names and Numbers. Then I tried to find out, okay, how do we get involved with this organization? Okay, how do we push for this? Then we actually pushed in terms of the legal counsel there to say, okay, we should have an Asian entity. So then we created what we call the Asian Domain Name Dispute Resolution Center. And that's been doing very well. And that's why in Hong Kong, we can see more cases coming for domain names. Likewise, we got China involved. We got Malaysia involved. We got, for example, Korea. And now Dennis will know that we're getting Japan involved. So the chances are, if we work together as a collaborative team, the chances are the whole world benefits. Whereas WIPO, yes, they're looking after the United Nations, but end of the day, they don't get other countries involved when they're working with domain name disputes. And I feel that if you get other countries involved working together, you can actually move this momentum forward. And I think that's when I started doing this. Then domain names, because the domain names is the crux. Because when you go to a web page, you need a domain name. So online, you still need a domain name. So chances are, unless we change the system, okay, unless people, young engineers and young scientists can change the system. But I think online dispute resolution is a trend. Like today, Jennifer would know, from 3 o'clock to basically 4:30, I was on the case. And the case wasn't really, for example, a Hong Kong case. It was a case of a different jurisdiction, but I was online doing it. So the chances are, if we didn't have the online system of doing things, I would basically say today, I can't do the seminar today. I have to fly to a different jurisdiction to handle this case. But with the tools that we can use, it can actually effectively and efficiently assist clients as well as lawyers to handle matters. But in saying that, given that I'm mature in age, I still prefer sometimes to have hard copies. Why? Because I realized at one time when I was in court, the Wi-Fi didn't work. And if the Wi-Fi didn't work, all your submissions are online, and then it was a disaster. I think the Wi-Fi also has to work as well. So I think if we in Hong Kong, if we can actually convince the government to have free Wi-Fi everywhere, I think that will work.
Can I ask, what makes Hong Kong so special as a place for arbitration? Do you often do cases that have nothing to do with Hong Kong in the sense of both parties not here? Incident didn't happen in Hong Kong, but they come to you, or come to someone in Hong Kong to resolve the dispute.
I think it's so special here is I think I have to give credit to the Bar Association, the Law Society, as well as the universities. Why? Because we need expertise. We need to train up the right people. Because at the end of the day, if you provide a service, if you're incompetent, no one's going to come to you again. So chances are we need to have good professionals. And one of the things in Hong Kong that I see over the years is our professionals, whether they're from different jurisdictions, whether they're originally from Hong Kong or from mainland China, they're very competent in terms of the service they provide. And I think that is something that I think the Hong Kong government uses the term the can-do spirit. And I think we do have this can-do spirit. We do want to provide services. They're not just the basic level services. We want to provide professional services that people respect, that we basically have given our best to do their job. And I think that's something that basically that we have in Hong Kong.
Excellent. Thank you. Last question from me, then I'll open the floor to see if there are other questions. We didn't talk about this, but what are your thoughts on AALCO coming to Hong Kong? And what are the wishes for it?
Now, I think everyone knows, I think most of the people know, including, for example, Dennis knows, I believe in collaboration. Okay, there's no point reinventing the wheel. Okay, you can create an organization easily. Someone said to me, Christopher, why don't you go and create a training organization that does arbitration mediation? Why are you having all these bodies? Do you pro bono? I said to myself, end of the day, okay, we need to work together. Okay, end of the day, the purpose is not to gain money. Okay, if you want to gain money, you might as well work in a bank. Investment bankers, you have more money. But the key thing is, if you want to provide a service, okay, if you want to make sure that it's the second generation, the third generation will provide our service going forward, so you can be proud of it, it turns out you have to commit. And I think by giving back to the community, I found that I get more in return. And I think that is something that we have to do at Hong Kong. Don't just look at me all the time, me. But at the end of the day, you have to give. If you give, you get something in return. Like there are many cases, suddenly, how did you find me? You say, oh, because someone recommended you. And I realized, oh, why did this person recommend it? Then I looked, oh, I helped him previously, so he recommended me. So the world goes around like this. If you keep on going outside to market yourself, the chances are you're going to spend a lot of resources, time and money. You might not be successful. But if people recommend you, the chances are there's no brainer. You don't need to go out and market anymore. Okay, and Jennifer knows, every time I'm in the office or the chambers, I don't wear a suit. I'm always casual. Why? Because I've been wearing a suit for the last 30 years. I'm getting fed up wearing suits. So the chances are I tend to basically work in office, like to sit down. And why I became a barrister is because I like to pursue something for myself. After so long, I've been doing things for other people. I like to do things now. I like the law. At first, I didn't like the law. When I did my PCRL, then somebody said, why did you do the PCRL? And so they don't become a lawyer. I went back to become an engineer. I says, oh, I just satisfied my needs that I want to finish this PCRL. I didn't want to go into law at the time because I didn't have a passion for law at the time. I still want to pursue engineering. But after a while in engineering, I thought, okay, the only one who really makes decisions going forward tends to be the lawyer. So that's why then I moved back into law. So I now really like the law. Because why? Because I'm learning things every day. Okay? And I think that's important. CBD, I totally buy into CBD. Some people hate it, but I buy into CBD because things are changing. When you talk about cryptocurrency, I'm not an expert, so I might have to go learn this for how much. But yeah, so I think CBD is something that we should do. It shouldn't be made compulsory, and you should be encouraged to do it. Okay, some people make it compulsory simply because people's nature, people won't do it if you don't make it compulsory. But I think as a human being, you have a duty to keep yourself competent all the way through to provide the right services for the client. If not, you're not doing justice to the client.
Thank you, Chris. Okay, fine. We're always out of time. Any burning questions from the floor? Otherwise, we'll wrap up for today. Any questions, Brennan? Thank you. With that, please put your hand together. The place. I support for down there.